Welcome to the current state of federal lactation laws. For our live listeners and on-demand viewers, we encourage you to ask questions for the speakers and the community to discuss, and we'll go through and answer those at the end. My name is Cassie Janikos. I'm the Chief Operating Officer of Healthy Horizons. I'm an engineer, operations leader, and I advise HR and facilities teams across North America on corporate lactation programs. Healthy Horizons helps companies in the US and Canada set up and maintain lactation rooms and new parent programs.
Hello, everyone. I'm Jessica Lee. I am co-director of the Center for Work-Life Law. We are a national advocacy and research organization based at the University of California College of the Law in San Francisco. And our work seeks to ensure that all people have the freedom to build and maintain economic security through employment and educational opportunities without having to sacrifice their health or their loved one's care. I'm really happy to be here with you today, Cassie.
And thank you so much for joining us. Today, we're going to cover a lot of different topics related to federal lactation laws. We're going to start with the PUMP Act, then the Pregnant Workers Fairness Act, Title IX regulations, legal developments, and some lawsuits that have come up, potential pitfalls to avoid, best practices, and fostering a positive workplace culture at your company. Before we get started, I do want to remind everyone to consult an advisor. Lactation laws do exist at multiple levels, at federal, state, and sometimes even local, such as the local ordinance we have in San Francisco. Laws do change often at the different levels, especially state and local, and accommodations may differ based on your location, and this information does not replace the advice of your lawyer. So why do lactation laws exist? So these laws are around for a variety of reasons. First, it helps moms maintain their milk supply so that they can regularly pump and feed their infant at home. Providing breast milk allows parents to have numerous health benefits like cancer reduction, and also supports infants with reduced rates of illness, SIDS, and obesity, and many more positive benefits. It also helps prevent engorgement, which can be really painful and have complications like mastitis. So there's physical health benefits. And these laws help us start the conversation around supporting employees. A lot of times, lactating employees may not always be comfortable speaking with you about these issues that can be very personal. That's why it's so important to be proactive with the support you're providing. We always recommend anticipating the needs and having something in place so it's not on the shoulders of a parent returning to work to figure out the program. And these laws help provide guidance to do so.
So the first law we'll cover today, you've probably heard about. It's the PUMP Act. That stands for Providing Urgent Maternal Protections for Nursing Mothers. This law protects the right to pump milk at work for at least 1 year following birth, and it applies to companies of all sizes. The primary standards of the PUMP Act were things that you are probably familiar with because they've pretty much been in place since 2010. But the big news of the PUMP Act is that it expanded federal requirements to cover all sorts of employees. So it now covers exempt and non-exempt employees, including folks who had previously been excluded from workplace breastfeeding protections, like teachers, agricultural workers, managers, and registered nurses. Under the PUMP Act, employees can seek remedies for noncompliance through a complaint with the Department of Labor or a private legal action. And unlike the old laws, the PUMP Act does have some potential for heavy damages. One thing to note is that there is a provision in the law saying that there can be a 10-day notice period before a lawsuit is filed, but there is no notice period for needing breaks or space. And an employer could be in violation of the PUMP Act if they don't provide a worker with the lactation breaks and space that they need on their very first day back to work. So again, that lovely point that you just made, Cassie, about being prepared in advance, getting ready is so important. At the end of the session, we'll also have some links available for you that will flesh this out a bit more. One of the things that we'll see is a resource on transportation workers. There are some different rights for folks who are operating motor coaches, trains, or airplanes. They have some different rights, but other than that, this law applies to just about everyone nationwide. So under the Pump Act, lactation rooms have to be available to any lactating employee on site whenever they need it. And that space has to be clean, not a bathroom. It needs to be essentially functional as a lactation space, right? So rooms without ventilation that are scorching hot or freezing cold might be a problem under the Pump Act. The space also, very importantly, has to be free from intrusion. Usually that means a lock on the door, but it could also be things like a curtain or divider, like you see here in the picture. It must also be shielded from view. So curtains on the windows, on the doors, maybe a sign on the door that people actually respect could make a lactation space suitable under the Pump Act. But finally, as we said at the outset, I think it's really important to also remember that the Pump Act applies in addition to any other state or local laws that might impact you. We'll give you a link to a place at the end of the session where you can go and just double check that you're familiar with the laws that apply in your state. Some states and localities do go beyond the requirements of pump by, for example, saying that you have to provide electricity, running water, or providing the space for a longer period of time. But no employer across the country should be going beneath the standards that you see laid out with pump.
Next. And a lot of times with our clients, we end up seeing that they take the state that they're in with the strictest regulations and applying it to all their sites for consistency. So looking at the state level is really helpful and beneficial.
That is a hugely important point, and so important because a lot of these lactating employees are talking. They know if Jane has better accommodations than Joey, that's going to be an issue. So you definitely want to pick the strongest standard you can and go with it so that you're not breeding resentment amongst your employees or causing unnecessary questions for your HR staff to sort through. So that was the space requirements under the Pump Act. Just a few notes on what pump requires in terms of the breaks. You heard me say this at the beginning. Nursing parents are allowed to take pumping breaks as often as needed. And that really varies from person to person. Somebody who is nursing a very young child, maybe they came back to work without a lot of maternity leave, they're very likely to need frequent breaks. Often, as a child ages, breaks are less frequent. But you never know what's going to happen. Growth spurts occur. All kinds of medical conditions come up. So people have varied needs. And the Pump Act requires employers to meet the employees really where they are with their own health and needs. Breaks under the Pump Act apply to any employee. So that could be someone who's on site, off site. It could even be someone like me who's working remotely. Any time that the employee is on the clock, the employer has an obligation to make sure that they're able to take care of their lactation needs. Breaks may be paid or unpaid, and the law on this can be a little bit confusing. So we'll also have a resource on this at the end of the session. But typically speaking, for the majority of folks, breaks would be continued to be paid for exempt employees, usually folks who are working on a salary. They don't have to clock in and clock out daily. They shouldn't have to do that for their pumping breaks either. Should be paid for any employee performing work while pumping or while using an existing paid break. Of course, you can't force employees to work. They need to be relieved of all of their duties. But if they choose, for example, to answer emails while they're pumping or answer the phone, they should still be paid for that time. They should also continue to be paid when those paid breaks are required by another federal or state law or municipal ordinance. So we actually have 4 states now where paid lactation breaks are required. That's Illinois, Georgia, Minnesota, and New York. New York just enacted a rule to require at least 30 minutes of paid break time each time the worker needs to pump. And then finally, again, there are some other situations where workers should be paid for that break time. Check out the resource at the end of the session for more details on that. We'd certainly recommend, allowing people to use their paid time off, make adjustments, or just pay them. But you certainly can't go below that floor. Now, the Pregnant Workers Fairness Act is another huge law that went into effect, started being enforced just over a year ago. I think the anniversary was last week. The Pregnant Workers Fairness Act is another law that protects lactating workers. It includes protections against discrimination, non-accommodation in the workplace for anyone who's pregnant, has a pregnancy-related condition like lactation. And it applies to workplaces with 15 or more employees. Those of you who have at least 15 employees are required to provide reasonable accommodation to employees who need them. And that could be things like light duty assignments, leave, even if someone doesn't have FMLA eligibility, or breaks to pump milk. The law also prohibits employers from retaliating against workers who request or receive reasonable accommodations related to their pregnancy or related condition. And again, this is a federal law that applies in addition to state and local laws. And the majority of states have similar laws already on the books. So hopefully this isn't totally new for all of you. But certainly a good thing to remember that these legal obligations stack. So again, look to the strongest protection.
And one thing I want to add about applies to 15 employees or more is a lot of times I get the question, is it 15 employees at a site or across the company? And it is across the company. So if you have a site with 14 employees and one with 1 that happens to have a pregnant mom, you need to make sure to support all your sites.
So the accommodation process is relatively similar to the process that we see for disability accommodations. It needs to be an interactive process. So this would come up likely when a lactating worker comes to you or comes to HR saying, I have this health need, I have to have some sort of change so that I can protect myself on the job. Then it is your designee's responsibility to assess that request, see if you can provide it. If it's not reasonable, if it would cause an undue hardship on your business in light of all of the resources available to you, then you need to engage in an interactive process to figure out if other options are available. And I have this TGIP here, timely. It should be a timely process. You don't want to keep workers waiting for a significant period of time, especially when it comes to pregnancy. Folks' health might be on the line very, very quickly. They often cannot wait for a long, drawn-out process. The conversation needs to be in good faith, where everybody's coming to the table with the intent of working this out and finding a solution that keeps the employee working. And then interactive, a true interactive process. This is not just send one quick email saying, no, we can't do it, and you're done. Some back and forth listening and collaboration is expected in this process to determine if there is any option available to keep this worker on the job while also protecting their health. I mentioned that the process is very similar to the ADA, but There are some pretty important differences when it comes to the Pregnant Workers Fairness Act. And I think the biggest one here is documentation. The EEOC has now put out its final regulations on how they're going to enforce the Pregnant Workers Fairness Act. I encourage everyone to take a look at them. They are long, but it is incredibly, incredibly helpful. And one of the important aspects that they address is the documentation requirement. So, under the Pregnant Workers Fairness Act, documentation cannot be requested for lactation breaks or space or other needs that are obvious. So, for example, getting a new uniform or bathroom breaks. Documentation can only be requested for less obvious limitations or accommodations. And in addition, what you request of the employee has to be relatively narrow as well. So employers can only request documentation that describes or confirms the condition or limitation involved. Again, this doesn't have to be a huge complication of pregnancy. It could be any limitation at all. Maybe it's I need to stay off my feet. I can't be on my feet for more than an hour at a time, or I have to wear a mask on the job because I'm at higher risk. It does not have to be anything severe, but so the documentation should describe that there is a condition or limitation. Formal diagnosis isn't needed. It can confirm that the limitation is related to or arises out of pregnancy or a pregnancy-related medical condition. So again, that very important link between pregnancy and this accommodation request. And then finally, employers can request documentation that would describe or confirm that that change or adjustment at work is needed to address the limitation. So it's really very simple. It could be, Jane needs to sit down for at least 15 minutes, an hour, because of this pregnancy-related health condition. We expect this is going to last for about 3 months. You don't need to know the entire medical history or the details of everything going on. Under the PUMP Act's the Pregnant Workers Fairness Act's very limited documentation standard. So that was a lot. For those of you who are at academic institutions, there is now another layer of legal protections that you need to be keeping an eye out for. So in addition to the PUMP Act and the Pregnant Workers Fairness Act, Title IX does require some similar obligations when it comes to employees. Also, students are now, lactating students now have rights under Title IX, and in some instances, state laws as well. So starting in August 1st, 2024, federal regulations will require that both employees and students be provided with lactation breaks and space. And this applies to any educational institution, whether that is a K-12 school, college, graduate school, vocational or technical school, med school, nursing. We hear a lot of concerns about med students. All of them are covered. Everyone who receives even $1 of federal funding for their educational program is now required to provide students and employees with lactation breaks and space. And if goofs occur, the Department of Education and the courts can intervene. Now, under Title IX, here we go. All of them, all of these institutions now have to be providing lactation breaks and space. And the risk here is either a lawsuit or potentially losing federal funding. And so this is very high stakes. And I will tell you, calls to our helpline have been significantly increasing. So I think more and more folks are learning of their rights. It's good to get ahead of this because the students and staff are certainly starting to expect lactation breaks and space, as something they're entitled to, not a favor, right? Next. So under Title IX, the standard is very, very similar to what we have under the other federal laws. Lactation spaces need to be clean and not a bathroom, free from intrusion and view. Again, that's lock on the door, curtains on the windows, things like that. And they also spell out that they must be safe and functional, right? We want to make sure, of course, that our students and staff are not putting themselves at risk in these lactation spaces. It should go without saying, but we've seen some very creative solutions here. And I specifically want to call out that the federal regulations do include this line about the lactation spaces being clean. So I think that does put somewhat of a requirement on institutions to make sure that the spaces they're providing, it's not just a janitor's closet with a lactation sign on it. They are actually clean and suitable for the purpose of expressing milk for young people, right? Babies. Also, an extra layer here, very similar to the Pregnant Workers Fairness Act, is that students must also be provided with reasonable modifications related to lactation. So that can include more time on exams to make up for the fact that students are spending a portion of their exam period pumping. It could mean different uniforms, permission to eat or drink. If you've ever been around a breastfeeding parent, many of them are ravenous and very thirsty. And it could also mean leave. Reasonable modifications for time off, whether it's for doctor's appointments or childbirth recovery, are also a part of Title IX. Great. So I've mentioned a little bit of what the enforcement options are, and I will share with you, people have been using those options. Within just months of enforcement starting back in 2023, we saw at least a dozen employers facing lawsuits under the Pump Act. We're starting to see more and more Pregnant Workers Fairness Act cases as well. And these early cases really emphasize the need for employer compliance and frankly, just the urgency around providing these breaks in space. There is no waiting period. The second an employee needs it, you have that legal obligation. There's a growing trend, unfortunately, of these lawsuits, particularly in industries with limited space, where there's hourly workers who have low power over when they can take breaks, and in male-dominated fields. So if that's you, hope you'll pay extra special attention to beefing up your support. And the full impact of these laws is still unfolding. We are still analyzing these. We are waiting for the cases to make their way through the system till we see how they're being decided. But one thing I can say is that, as awareness of this grows, it is possible that we're going to see more lawsuits if the employers aren't stepping up and meeting their end of the deal. We've certainly seen in a lot of states that enacted these laws, things got clearer, right? So you now have an instruction manual of what you need to do. But unfortunately, we're still seeing a lot of employers just haven't read the manual. So really grateful that you all are here and paying attention to what you can do to get this right. Next. Here's just a smattering of some of these lawsuits. I know none of you want to be in these headlines. You see breastfeeding workers target fast food and retailers under the new law. We've seen class actions and major lawsuits at some of the most giant companies in the United States. We've also seen, the typical mom and pops getting hit with this. Breastfeeding moms suing a Michigan bar under the new pumping law. So it really can be varied, but it's important to remember no one is immune from this. We have lactating workers in every field and every industry, and they all need support. None of us want to see your name in lights. One more point, though, that I will make about the lawsuits. We do have an injunction against those new Title IX regulations in 10 states. We've seen some attorney general and some interest groups raise challenges to the new Title IX regulations. Federal courts have put the enactment of that law on hold in Idaho, Indiana, Kentucky, Louisiana, Mississippi, Montana, Idaho, Tennessee, West Virginia, and unfortunately, my home state of Virginia. But it's very important, any of you who are in these states, that you still pay attention and start preparing for the August 1st enactment of the new regulations. Because, well, first of all, Title IX generally still applies, even as the update is paused. But I think more importantly, full legal enforcement could be reinstated with as little as 1 day's notice. So if you don't have your lactation spaces mapped out, if there's no plan for getting students the help that they need, and a court suddenly makes the law go into effect in these 10 states, you could be sued the very next day, and none of us want to see that. All right. So the next section, we're going to be talking a little bit about potential pitfalls, ways that we've seen some folks slip up, so that hopefully you can avoid some of these pitfalls. The first one is over requesting documentation. We do not need doctor's notes for basic lactation accommodations like break time and space, or for anything obvious like a larger uniform. I've seen, we've actually recommended for a long time that workers consider bringing in a doctor's note just because it helps them feel more empowered, asking for what they need in the workplace. Some employees might want to do that, but the employer cannot require documentation under the Pregnant Workers Fairness Act and the PUMP Act and Title IX, all three of those federal laws. Employers are required to provide basic break time and space without medical documentation. That all said, notes can be requested for more complicated cases. But as I went over with the Pregnant Workers Fairness Act, the information requested should be as limited as possible. And you want to assume the parent is being truthful to avoid violating their privacy and frankly, to retain them as a loyal and eager employee. There's also, some of these federal regulations have the preamble to the regulation talks a bit about trusting employees, and the fact that lactation is so incredibly common. It's the norm for the vast majority, actually, of infants born in this country. We should not assume that somebody's not going to need this, right? We should assume that they are going to need this. And really trust that they are being responsible with that support.
The next potential pitfall is breaks. So it's one thing to have a policy, but you also want to make sure in practice that parents have the ability to actually take those breaks. One example is, let's say you have on-call engineers and she's pulled into an emergency project that's going to take a large amount of time. Make sure there's a backup plan so people in those situations can step away and actually take their breaks to pump in practice. Another is avoiding kind of the unexpected consequences of taking breaks, like reduced salary, diminished career opportunities. We were talking to a customer who had a call center, and they had very strict rules around number of calls, the number of minutes on the phone. And they were, you can unintentionally dock someone for taking breaks. So take different job responsibilities and keep those in mind to make sure you're kind of keeping that playing field level for the pumping parent. And lastly, there still is a right to lactation breaks after 1 year. For example, American Academy of Pediatrics, AAP, recommends breastfeeding for 2 years or more. So a lot of parents do go beyond that 1 year to pump.
And thank you for flagging that about those unintended consequences. I think that's so important. You need to adjust your metrics to reflect the amount of time the employee is working and count those breaks out so that they are really and truly breaks or accommodations under the Pregnant Workers Fairness Act. That is certainly a key component of both of those laws, to not penalize workers for needing that time.
Another potential pitfall is availability and accessibility. Some employers will put perhaps one room per site, but not keep in mind how accessible that is if someone's working in a different building or, maybe 10 floors up or something that's quite far away. So you want to make sure that the rooms are actually accessible and usable to all employees. Keep in mind that they have to be open at all times. So if you have someone working after hours and part of your facility is locked down, make sure that the parent can still access those rooms. And if a room is occupied and you have another parent who needs to pump, make sure there is a backup space and you've done that space planning to make sure you have multiple rooms, backup plans, and that everyone can have access. That's one of the things Healthy Horizons helps with is usage and making sure you have the right array of lactation rooms. And reasonably accessible. So some examples of that is a streamlined process where someone doesn't have to go to a security guard or the front office every time to borrow a key, and the examples I gave earlier. Another one is not planning ahead. So I know we've spoken a lot about being proactive, but that really is one of my top tips is always be proactive and have something in place because it takes a little time to locate a space and make sure everything's compliant. So have that ahead of a parent returning. Communicate what's available in advance. So you want to make that readily available on your system so someone who maybe is planning to have a baby but not pregnant right now can kind of see what you have available, or when someone's on maternity leave, they can look up your policies and return with confidence. Set up that pipeline. Even if you don't have lactating employees right now, that's another thing I hear quite a bit is we don't have anyone who's pregnant right now. But you want to think you don't have anyone who is pregnant right now. You also don't know who you may hire in the future. And you want to make sure, you're creating an environment that's welcoming for women as well. And also keep in mind your visitors, vendors, and other people who may be on site, who may be pumping. Another best practice is room planning. So make sure you have really clear signage, update your wayfinders, and make sure the rooms are easily located. You want to avoid having kind of a room within a room, like a maze to get to the space, so people know where they are. When you're putting the rooms together, I highly recommend complying with the American with Disabilities Act ADA standards, so they're accessible for all types of people. Place rooms close to work areas, but you want to avoid like high traffic, noisy areas. It can be really uncomfortable to pump and hear like your coworkers talking about what they did over the weekend. Or also kind of people don't want to be watched going into the room and kind of having that coworker just staring at the door. It can be really uncomfortable as well. And then ensure, of course, you have enough rooms for your population, and then work with a design service like Healthy Horizons to plan out your spaces.
From the legal perspective, these spaces have to be available each time the worker needs it, right? Whether that's 12 workers or one, as long as it's available when they need it, you're meeting your legal obligation. But I'm really curious, Cassie, if you have just like a general, like back of the envelope standard about to estimate how many rooms would be appropriate for the population, or how do you all sort that out so that folks can plan proactively before the folks request it?
Yeah, that's a really great question. We look at company size. We also look at layout of the campus, and then we do estimations based on that. So typically, ideally you want a room on every floor or every other floor in a building, but it also depends how big your floors are. Like you might have a factory with 5,000 people in it. Of course, you need more rooms for that. But look at total number of employees and your building layout are kind of the two things I recommend looking at. If you do have data on how many pregnant people or how many pumping people you have, that's really valuable too. But a lot of times companies don't always have those numbers.
Thank you.
Another best practice around fostering a positive culture. So even if HR and leadership are on board, it's really important to train supervisors, the people who are interacting with employees on the day-to-day basis, to avoid introducing risk or them accidentally saying or doing something wrong. So training is really important across the organization and kind of making it a cultural norm to destigmatize lactation. In some ways you can do that is putting it in your policies that everyone has access to, in your handbook, in your intranet, and making it visible as something that's just kind of the norm to have at work. You can also survey pumping program users, people using the lactation rooms proactively to see what needs they have and if there's any problems popping up, so you can avoid them before it becomes a larger issue or potentially a lawsuit down the road. And of course, maintain your lactation rooms. It's so important, not just to set up a nice space from the beginning, but to continue to keep eyes on it and make sure it's meeting standards. We see companies who set up gorgeous spaces, and then 3 months later, after the first group of people have used it and you have new users coming in, it's kind of not as nice. And you really want to keep eyes on that because it's something janitorial isn't always aware of, or maybe they have many rooms they're maintaining and don't realize. Okay. And then for resources, we put together a bunch of resources for you. We will be putting these in the chat, so you'll have all the links. So we have a resource on creating a lactation program, the workplace law map that Jessica mentioned. It is wonderful. It's interactive. You can kind of see what additional laws are in each state. A guide to seeking medical certification, and a guide to pregnancy accommodation as well. And then in addition to that, we have a Title IX toolkit for people who are receiving that federal education funding, the link for transportation workers' rights, paid lactation break guidance, a lactation room setup guide, and then a place to source lactation room specific furniture as well for your room. So lots of good material. And if there's any other resources that you'd like or you think would be helpful, please reach out and we can look into that or help have a conversation with you around getting you the guidance you need. And with that, we're going to open it up for questions. And please feel free to write them right in the chat. Okay, so first one that came through, I am a remote worker and my company requires my laptop camera to be on at all times. What should I do?
Yeah. That the standards under the Pump Act is to have a lactation space that is free from intrusion and view. And the Department of Labor has, which is the agency that enforces the Pump Act, has made really clear that that's not just in-person view, right? That includes any form of viewership. So that would mean for a worker who is required to have their camera on while working remotely, permission to have that camera turned off, and to truly make that lactation break a break. But I think that's such an interesting question because it also points out some other settings that we have seen this come up as an issue. So, for example, we know a lot of places have break rooms or even manager's office and like fast food settings where there are cameras. Wherever that employee has as a lactation space should be a space where they can pump, dress or undress without being in view of a camera. And I've actually seen, unfortunately, a couple of cases now where workers have been told that the camera is off and it really wasn't. So that could be permission to cover the camera, turn the camera around, ideally have a divider or something extremely, extremely clear to let that worker know that they are not being observed in that moment. And just, again, for those remote workers as well, it also means the break time. All of these standards apply, again, wherever you are.
Next question is, what should I expect if lactation laws are not followed at my company?
Yeah, I mean, I think the ideal is that you reach out for help for a second person. If that worker is having problems, hopefully they'll reach out to you. But I would say, sometimes, I think most often folks are going to the federal agencies like the EEOC or the Department of Labor for assistance with their lactation, break time and space problems. Occasionally, a worker will have a situation where they end up going straight to a lawsuit. Usually that's happening, though, if there's like pretty egregious discrimination or harassment as well. They'll try to ramp up that timeline a bit. But it's the EEOC and the Department of Labor's Wage and Hour Division are really on the front lines of enforcing this. And I definitely encourage employers, have your HR folks or your compliance professionals check out the guidance that they have put out. The administration has been extremely proactive about putting out frequently asked questions, doing trainings, making sure that employers really have the tools that they need to comply with the laws. And it's great because you can see this is how they investigate cases, right? So you have the roadmap very clearly laid out for you. It just means asking those folks who are responsible to take the time to dig into it.
Yeah, absolutely. And I would say also escalate it internally. If you're not in HR, let your HR person know so that they can support you. Most companies want to do the right thing and want to have a really positive workplace. So a lot of times I found if, you let your HR representative know, they're more than happy to look into it and support before it needs to go to, an agency or an attorney.
Absolutely. So we run a helpline for workers. We also support employers with their questions about the laws, but we mostly hear from workers. And so often it's exactly what you pointed out earlier, Cassie, where there's a supervisor who hasn't been trained on this, and they are the source of the issue. As soon as that worker identifies a person in HR or leadership to support them, it all gets resolved. But really that first line staff is often not very well trained. So we want to make sure that there is a really clearly identified point of contact at the institution so that the employee who doesn't get their needs met isn't immediately running to file a complaint externally, but they know the pathway to get some more support there. Mm-hmm. Also, just want to echo that point about training the supervisors. Please train those supervisors, and really, I just so encourage folks to take this out of the silo. Just like meal breaks are something everyone knows about, bathroom breaks are something everyone knows about, lactation breaks should be considered the norm and something that applies to everyone, because even if you as an employee aren't going to be using that yourself, one of your coworkers is likely to be using it, and normalizing, destigmatizing that is going to be helpful, not only for the compliance issues and preventing harassment, but also just for building a more supportive culture that breeds employees who are more loyal and eager and productive.
Absolutely. And that also goes back to having your policies like in your handbook and intranet. With that, also include who to reach out to if they have an issue. So that's readily available, especially at large organizations where it can sometimes be a little challenging to find the right person who owns a specific project like lactation rooms. And then another question we received is, what are the legal protections for pumping beyond 1 year?
Yeah, so we started off talking about the Pump Act. I love the Pump Act because it sets a really clear floor. That's those breaks as needed in a space free from intrusion and view. It's easy, right? But easy to explain, but the Pump Act only covers the first year after birth. So those hard, fast rules that apply typically without exception only cover you for a year. Beyond that first year, though, that's where we're going to be really relying on the Pregnant Workers Fairness Act. The Pregnant Workers Fairness Act does not have a timeline. It covers everything from fertility treatment to morning sickness to postpartum depression and lactation. It is very, very expansive. And so if someone is still breastfeeding at 18 months, 2 years, or beyond, they would have a right to lactation breaks in space, so long as it is reasonable in light of that workplace setting and resources.
Absolutely. And then I would add that some state laws actually do have protections written into the law as well. So in California, for example, there's not a limit to how long a parent can pump, and other states have, different lengths that they support. So there's several layers to the protection beyond 1 year.
Yeah. And can you correct me? Is the AAP recommendation, it's 2 years now?
Yeah, it's 2 years and beyond.
Okay. Yeah, so just as I think over 80% of infants in this country start off being breastfed, I think that as awareness grows of the health benefits, you're going to see more and more workers needing to have those lactation breaks for a bit longer. But under the current legal regime, that's okay after a year as long as it's still reasonable.
And it looks like that's it for questions for today. If anyone has any questions that they weren't able to share today, please feel free to enter them in the comments or email services@hh-bc.com, and we're happy to answer additional questions. And if they're very legal in nature, we may forward them along to Jessica to help you with. We really appreciate your time today, Jessica, for joining us and sharing your wisdom and your experiences around lactation laws. And to all our viewers today, thank you very much as well. We hope to welcome you to another event soon, and best wishes supporting parents. Thank you.
Thanks for all you do. Take care.